In this video, we want to turn our minds to intellectual property. And in particular, we want to look at the protection of intellectual property. When we think of physical property, for example, land or houses or cars or something physical that we can see and we can touch, it's tactile, we think of the property being assigned to some person, legally assigned, so that if you own a car and I take your car without permission, I'm stealing it. I'm in violation of the law. And that's how society operates. We assign property rights. So as individuals, we own certain things. Sometimes they're not documented. Something small like a pencil. A pencil may not be written down as particularly your ownership, but you do own it, unless you've stolen it or taken it illegally. So we're accustomed to thinking of property rights in the context of physical goods. But intellectual property, well, that's slightly more problematic, because here we're considering ideas, and we're considering the protection of ideas. Somebody has an idea to do something, to make something, but they're afraid if they make it, others will copy it. So they will not get a return on their idea. By the time they have made their idea into something physical for the market, others will have done so also. They will have produced the similar idea, or stolen the idea and produced something. So ideas need protection. That's the point. And that's what we're going to deal with in this video. Intellectual property is composed of two terms, intellect and property. Clearly, intellect resides in our heads. That's where we think. That's where we imagine. And then we have property. Property is something that we can assign ownership to. We say, this is my property, this is my pencil, this is my house, this is my car, these are my possessions, and I own those. These are mine. But intellect can also belong to a person, in the sense that if I have a good idea, if I write a poem, it's my poem. And any revenue accruing to the poem accrues to me. It comes to me. If I write a book, a novel, and it becomes successful, it's my novel. I get the benefits from it. But it is just something I've taken out of my head. It's an intellectual process. I have perhaps written it on paper and given it to a publisher. So we have two parts here. We have the intellect and the property. And here we're trying to protect ideas from being stolen. Intellect in this context means the product of the mind, the product of intellectual effort. So it's not just our ramblings, our vague, unstructured ramblings, which we all do. We just talk without much thought a lot of the time. These are just our ramblings. But sometimes we may focus in and come up with an idea. And that idea should be protected because it may have commercial potential. Now, in the context of business studies, this is very important. In the context of innovation, innovations are normally based on the ideas of some entrepreneur who wants to innovate something, wants to change something, change a product, or bring about a new product. And the entrepreneur wants to do that because the entrepreneur has an idea. But if the entrepreneur starts to discuss his or her idea in public, then others competitors may start to produce it. So in effect, his idea has been stolen. So we need a framework to protect the idea. Otherwise, entrepreneurs will have no incentive of bringing forward new ideas because they're not going to get rewarded. This the same applies to music. Someone composes a piece of music or a song. And if it's a nice piece of music and people like it, then that person is entitled to some reward. If the person just makes the piece of music and puts it on the internet and it becomes hugely successful, lots of people download it, but they don't pay for it, it's tantamount to stealing a nice piece of music. They don't own it. They have perhaps copied it illegally. It happens with films. It happens with all sorts of intellectual property. If the outcome of the intellectual effort is original, unique, and useful, it's similar to a monopoly situation. It may be assigned to the originator's property. It is a monopoly because if an entrepreneur has an idea to make a new product, then it's new. That means it's not similar to anything else. It's new. And that means if this product is produced, the entrepreneur will have a monopoly in that product. But in order to encourage the entrepreneur to have good ideas and to bring forward good ideas, as a society, we give that person some period of time to get a high return on his or her idea. They're allowed to earn monopoly profits. If the product is successful, they should have a period of time before others are allowed to copy. So they should have a period of time to maximize their return on the idea. The concept of intellectual property is similar to tangible property. It's very similar to the world in which we live, the physical world in which we live. And in this regard, its possession and ownership may be protected by law. So, in the same way as your house or your car or your computer or any of your possessions is protected by the law, they belong to you, and if someone takes it, it's illegal if they haven't got your permission. The same with an idea. If you can demonstrate it's your idea and it's a good idea, it has some sort of function or some sort of use, then it's possible to protect it by copyright or by patent or by communicating with the legal system that this idea belongs to you. And if someone takes it, they're in violation of the law. Now, the background to intellectual property. Well, laws relating to intellectual property date back through history. In Venice, for example, in 1474, there was a monopoly granted for 10 years to the originator of a commercial idea. So it goes back in time. It's been understood that people who are entrepreneurial, people who are innovators, who are agents of change, they have to be encouraged, because that's how our society develops. And as a consequence of this, the legal system approves the ownership of ideas. It codifies them. It says who owns what idea. It's approved by law, in a sense. And if someone steals the idea, they're in violation of the law, and an action may be taken against that person. It's not a criminal idea, it's a civil idea. It'll be one person versus another. One person saying, It is my idea and I have protected it, and this person has stolen it. So they will fight it out in court. In the UK, the Statute of Monopolies in 1624 and the Statute of Vannes in 1710 are two famous examples of early intellectual property law. So it wasn't just Venice, it's all over. People almost throughout history have recognized the importance of protecting ideas. This is your idea, providing you have written it down and registered it and it is associated with you, then you have a right to use it for a period of time according to the law, and during that period of time no one else can use that idea. So you have a right to make a return on your good idea. So there has been a lot of protection of intellectual property throughout history. It's not just something of the 20th century or the early 21st century. Now, the types of intellectual property. Well, intellectual property rights apply to various types of intellectual property. For example, copyright. This is a protection for the form in which intellectual property is presented. Copyright does not cover ideas or information, but it protects their presentation style. So the copyright means that there is ownership of the style of presentation of the idea. And that may sound a bit odd, but it depends on country to country exactly what is written into the legal framework. Many countries will include the idea itself and say there is a copyright on the idea. So it's not just a question of finding someone's poem that is very popular and changing the style of presentation, but writing the poem out again word for word. The structure of the poem, the style of the presentation, the structure of the poem may be protected. But of course, the person writing the idea down, that's going to be copyrighted, doesn't own the words. The words are in the public domain. Those are the language of the country. But the sequence of words and the way the words are used, that could be protected. Patents or patents, depends on how you pronounce it. These are rights granted to inventors, giving them a monopoly for a number of years. It's their reward for being inventive. So someone comes up with an idea to build a new machine, or vary something with the machine, or they have invented a new battery, or they've invented a new piece of equipment, or they've come up with an idea for computers, or whatever it is. They can patent it. That means it's protected. It means they have the rights to the revenue stream associated with that patent. It's theirs. And this will last for a number of years. It could be 10 years, 20 years, depends. And after that period, other companies can copy it. But during that period, the person who originated the idea and built this prototype and tested it, they can have a patent on it. We've got trademarks and design rights, and you can look these up separately, but different countries will have different rules about whether a trademark is protected or not. By and large, names tend to be registered. The names of companies are registered to a particular company. Coca-Cola owns Coca-Cola. So we have no right to use those words. Those are registered words to one company. I cannot pretend to own a company called Microsoft because it's already taken. And rightly enough, the people who have built Microsoft, through their ingenuity and through their ideas, want to protect the name so that it's associated with their particular products. So it's not up or open to me or to anyone else to just form a company and give it the same name. And likewise with trademarks, particular designs may be protected as well. Granting intellectual property status may be discussed under three distinct headings. Protection under this law usually grants monopoly status to the creator, and this is seen as a reward for creativity, as I said earlier. The person who originated a good idea should be allowed a period of time in which to make a profit off that idea. If they're not allowed that period of time, they have no interest in bringing it forward. What's the incentive? The incentive is removed if they're not allowed to make this profit. And as a consequence, all of us in society will be poorer by virtue of the fact that the idea did not come forward. So, the reward financial incentives, the holder of the right may reap financial rewards over a number of years. And it's seen that that is fair because they've come up with an idea that no one else had. We all benefit from the idea. And later on, it will be in a competitive situation where other companies will be allowed to use it. But only after the originator has had a period of time in which to make profits. It's seen that this will encourage economic growth. Protection of intellectual property gives incentive to be creative and innovative. And creativity and innovation leads to economic growth. So society will grow and develop and be better. There'll be more employment, more welfare. And also the citizens within the country will pay a tax, and there will be better education, better health, better roads. The society in total will improve as a consequence. Morality. Well, protection of intellectual property is based on three theories. Personality theory. Intellectual property is an extension of the individual. The individual has a right to his or her ideas and the protection of his or her ideas, much in the same way as an individual has the right to live and not be in any way encumbered in the activity of living. So there's a personality right associated, or a morality associated with the protection of intellectual property. It's their idea, so they should be allowed to benefit from it. There's also what's known as a utilitarian defense. Intellectual property pushes society towards further innovation and investment. So we all benefit. The utilitarians were a group of philosophers in the 1800s, including people like John Stuart Mill. They believed that society would be advanced through liberalism and through the promotion of an acceptance of tolerance, and as a consequence of this, society would develop, but the benefits of that development would be shared around the society. It will eventually filter out through the various market structures until it gets to just about everyone. So the idea was that a good idea will initially bring high rewards to the person who owns the idea, but eventually we will all benefit from it. So just give it time and it'll filter out through society. And the Lockean Theory, named after John Locke, another great philosopher of the past. Intellectual property, according to this theory, it's justified because it's deserved. It's the product of hard work. And if somebody works hard on an idea, then they deserve to make a good return on that idea. They're entitled to it. It's their idea. They have developed it. We didn't do it. They did it. And they are entitled to a return. And the rest of society should understand that and allow it or agree to it happening. So these are some of the defenses of intellectual property. We've got an idea that intellectual property has been around for a long time. It's not the rights associated with intellectual property is not something new. We can trace it back to Venice, and probably skilled historians, knowledgeable historians, could probably trace it back all the way to whenever, back in eons of time. But we can certainly track it back to Venice, and later on in England, the Statute of Anne and so on, as we mentioned. We know why it's important, because it generates new ideas. It promotes the growth of society and the development of society. New ideas are welcome, and we also have the protection of the ideas, because it's only fair that the people with the ideas should reap a reward. But that's all we need to cover in this session, so let's leave it at that and say thank you for watching.